Good evening, everyone. I'm alzheimer'sfl. I'm an estate planning and elder law attorney, and I do probates, wills, trusts, and I do elder and probate and guardianship mediation. And our topic tonight is what is probate and why does everybody want to avoid it? So let's get started. Okay, so probate, this is the technical definition of it. Probate is the process of collecting assets, paying bills, and transferring probate estates of someone who is deceased. And we'll talk about what that means in a minute. The court is also declaring the will to be genuine and will appoint someone to administer the estate. In Florida, that person is called a personal representative and not executor. Everyone will understand if you say executor, but in Florida, we call it personal representative. So you just can't present a will to access assets. The will means nothing till the court determines it's genuine. Okay. So typically clients will come to me and say that they, why don't, the will says everything goes to me or everything goes to me and my brother or whomever. Why do I have to go through a probate? Well, we'll talk about that in length as we go, but the will means nothing until a court determines it's genuine, that it's the last one, that there's no issues with it, etc. So you can't just bring a will into somebody and into a bank, whatever, and say, I named it. They're not going to take it if you've ever had that experience. So what is your probate estate? So the word estate, it's really not fair. It has so many different definitions. So there's your taxable estate. That's if you have estate taxes that are due and you'd have to have more than, I think, 11 or 12 million, what it is now. Your trust estate, if you have a trust, etc. But most people use the word estate to mean everything that they own when they die. But for our purposes, we're really only concerned about our probate estate. Excuse me just a second. So your probate estate, wait, let's do this. Yeah. Probate estate are only the assets that you own in your own name alone when you pass away. So they have no beneficiary designation. They're not jointly held with somebody else. They're not in a trust. And we'll talk about trusts a little bit later in depth. It's something that in your own name that you own, what's called tenants in common. So if you own a piece of real estate with somebody else and it's not joint, doesn't say joint, that means you own 50% and that's in your name alone. So anything that has no beneficiary designations or names on it or in a trust is going to go through probate. But only your probate estate goes through probate. So for example, I have a $10,000 account in my own name, and I have a $50,000 account jointly with my husband. When I pass away, he's going to only have to do probate on that $10,000 account that's in my name. He's not going to probate the $50,000 because that's going to go pursuant to the title, which is what we're talking about on this slide. So assets that pass outside your probate estate are assets that are in a trust, whether it's revocable or not revocable. Most of them are going to be revocable. Assets that have typically beneficiaries, so those are IRAs, insurance policies, those kinds of assets. Anything that you hold jointly, and it should say jointly with right of survivorship, but most bank accounts and brokerage accounts are right of survivorship. And anything that says payable on death, different institutions use different words. So POD, payable on death, TOD, transfer on death, joint tenants with right of survivorship, JTROS. Those are going to all go outside of probate. Those are going to go to the person or persons named on the document. These assets are going to go directly to the person pursuant to the title. The title always trumps the will. So let me give you an example. Let's say my parents left their estate to my brother and I, and they wanted us to get the estate 50-50. But my brother lives in New York and I live down here. So they took $10,000 and they put it in a bank account with my name on it only so that I could pay bills or do something else. And the rest of the money they put in a trust and it's equally to the two of us. The money in the trust is going to go equally to the two of us. What's going to happen to that $10,000 account? Is it going to go equally to the two of us? No, it's going to go to me because my name is on the account. It doesn't matter what the will or trust says. The title always rules. The title always trumps what the will says, which is why we'll talk a little bit about why the will is not your most important document, regardless of what you hear and read every 5 minutes. Another example, this is the more common way this happens. When my parents set up their estate, they put everything in a trust and they left everything jointly to my brother and I. But they happened to have an old insurance policy that they left to me because I was the baby and they wanted to make sure I was taken care of. And when I became not so much of a baby, they forgot to change it. And that's a $100,000 insurance policy. Where is that going to go? Again, that's going to me. Am I going to share it with my brother? We're going to assume the word share means no. So even though I might personally do that, we're not going to rely on that happening. So it's really important that we coordinate our beneficiary designations and we always know how everything is titled, because that's how we run into trouble. That's probably almost all of my probates are something where somebody messed something up. Okay. Why is this turning? Going the wrong way. Okay, so this is why people want to avoid the probate process. You have to, first thing you do is have to pay the attorney, because the attorney in Florida, there has to be an attorney for all probate proceedings. There's tons of filing fees. Then somebody technically has to open the estate. That's usually the personal representative, executor. That person has to be a resident of Florida or a close family member. And you'd be surprised how often that can be a problem. I have somebody who is a dear person in my life, and we consider her family. She's family of family. She lives in Staten Island. She's not eligible to be my personal representative. So you have to make sure you name somebody who is eligible. Then we file all these papers to open up an estate in the court, and we advise the beneficiaries, and we file the will with the court. And then the court appoints a personal representative or executor. And at that point in time, the executor or the personal representative goes and collects all of those probate assets. So goes to the bank and closes those bank accounts and puts that money into a estate account, brokerage account, whatever, and collects it and moves it all together. That's typically how it works. After we have the personal representative appointed, the next thing is really important. We have to provide notice to creditors and give them an opportunity to make claims. And we have to wait 3 months for claims to be filed before we can really distribute anything. So in the meantime, we're preparing an inventory and paying the expenses and paying the creditors' claims and preparing an accounting, tax returns, etc. And trying to, at that point, distribute the assets and close the estate. And it sounds quick, but it usually takes the better part of a year to get it done. I mean, you really have that 3-month creditor period in which you really can't do a whole lot in terms of distributions. Why would anybody want their estate to go through probate? Well, most people don't, but sometimes people forget they have assets that they have in their own name. That is really the most typical. Is I'll have a client who we did a trust for, and she funded the trust, and again, we'll talk more about that. But for some reason, she forgot about that account. She opened her name that she meant to put somebody's name on and never did, or got sick or whatever. Sometimes it's just poor planning, lack of information. Sometimes people are believing all of these things that they hear and they read on TV. And I can't tell you how much stuff is wrong. It's just wrong. I just did a blog on Susie Orman. I mean, she's wrong. She's just wrong. I mean, I'm not gonna say she's wrong on financial because I don't know that, but on estate planning, she's just wrong. So you really, maybe you got poor legal advice. Sometimes people just procrastinate and they don't want to do these things. Some people think lawyers are selling revocable living trusts, and we'll address that a little bit later too. And sometimes people don't give a damn. They just say the kids will take care of it. I get that once in a while, not very often, but once in a while. So common mistakes in estate planning, even if you do it right. This one I had recently, I have no idea why this was done, but somebody in the financial world told the person to make my estate as the beneficiary of either an IRA or insurance policy on the beneficiary forms. Well, that is asking for a probate because they're asking them to go into your probate estate. That's almost never a good idea. So if someone ever tells somebody to do that, talk to somebody, me, about that's not usually a good idea, almost never. Sometimes people don't update their beneficiary form. So maybe maybe a child passed away or something and they don't update it and now it's going to go wrong or it's going to go into the estate. We'll talk about funding trusts, but sometimes people just don't handle their trusts right. Sometimes there's safe deposit boxes that are holding assets. Sometimes there's a lot of cash. Bonds are really a one that people forget they own in their own names, or they may own it jointly with their spouse and one person died and they didn't bother to put it in the trust because it's a pain in the neck. Old stock certificates, if it's not being held by a company, you don't see those as much as we used to see some Disney stocks once in a while. And then there could be a lot of personal property that somebody is hiding or put away, and that can be worth something. It can be paintings, can be art, can be, jewelry, can be other things that have value and may need to go through a probate proceeding, even though we would normally not have a probate for personal property. So the problems with probate should at this point be somewhat obvious. It's time consuming. It's costly. You're more likely to be contested than with a trust. And that's because if you open up a probate estate in the court, it's really easy for me as an outsider or somebody contesting it to just file something in that probate proceeding. But if I want to contest a trust, I have to actually sue the trust and sue the trustee. And that's a very big difference. So that's a real reason we avoid probate. It's much harder to contest what you're doing. It's public. Not that anybody's going to necessarily look at it, but what you have that goes through probate is going to be public. Again, you can't sell anything until that personal representative is appointed. And you can't distribute anything until the creditor period ends. So it's, again, really time consuming, a pain in the neck. And, clients really don't want to hear about the creditor period, and they don't want to hear that these, the court, that this COVID and the courts are not doing what they're supposed to be doing or any of that. So we really try to give our clients at the beginning some, expectation of how long everything's going to take. And, it's unfortunate, maybe something went wrong, whatever, but in the parents' planning or whatever, but we really try to give an expectation so that everybody's not wondering why things aren't happening. Okay. So are there any benefits to going through the probate proceeding? There are a few. One second. There are a few. So, for example, that creditor period that we just talked about, we publish in a newspaper to give creditors an opportunity to make claims. And they have 3 months to make claims. And we're required to pay all those claims and all claims that we know about, even ones that aren't made. But then it's over. after that 3 months and the known creditors, everybody else is barred. So that bars future creditors. In most families, that's not an issue. But again, with some people, if we don't know they have credit, if we don't know that they have creditors out there, they've had lots of bankruptcies or issues or whatever, we may want to open up a probate just to get creditors barred from making anything. It's easier to resolve disputes if there's a probate. Like we said before, you could more easily just file something in a probate proceeding than you can if you have to sue a trust. So that gives us an opportunity maybe to mediate or to ask the judge for some kind of direction. So there are times when we want to resolve disputes and we want the court to be involved. We can avoid, the personal representative can avoid more personal liability this way also, because we can have people either, waive their rights against the personal representative, or the court, when they close the estate, will waive rights against the personal representative. And sometimes that is important to do to make sure that we have some finality. Don't have that same finality when we use a trust. If there are multiple wills or parts of wills are missing, that's when we need a probate. Or if the will or the trust is unclear, we may want the court to give it its official stamp of approval. 30 minutes. I'm at 15, okay. All right, next section, before we get on to trusts, are some special issues with real estate. And these are things that come up with some frequency in our office, and wanted to make sure that everybody who works in real estate understands them. So the first three kind of go together. Before doing anything, the realtor needs to determine who owns the property. Just because you walk into my house and I tell you I own this house doesn't mean I own the house. So you could have a situation, and we have it all the time, where the people think they own it because mom left it in a will, and you're getting close to that closing and oops, the title company says they don't own it. So only if that property is a probate asset, meaning it's only in somebody's name and you haven't done that probate yet, you're going to have really unhappy sellers and buyers. So only the court-appointed personal representative can sign the contract. And you have to make sure that the contract names the personal representative as the seller. Again, this is for a probate asset, not if it's in a trust. But if there's a probate asset, you have to do this, and you want to do it quickly because people generally want to buy and sell quickly. So you're going to want to determine that title immediately, and then pull the records. And if you're not sure, you need to double check. You need to look at the will and talk to the probate attorney and get a probate attorney as soon as possible if there's no, if their property is owned by a decedent and it's not owned by a trust. So an example of this will be that I had a friend who came to me, and her mother had said to her 100 million times, I've taken care of everything. I've taken care of everything. I've taken care of everything. So they listed the property, and when it came to closing, the closing agent couldn't close because the property was still in the deceased's mother's name. They'd never done a probate, and they just took the mother's word that everything was taken care of. They're not lawyers. So, oops. And that really would have been the role of the realtor, to make sure that you know who owns the property at the very beginning. So you need to look at the will, and you have to title that contract in the name of the personal representative, and that personal representative has to have been named by the court. So you need to get moving quickly on this if there's property that needs to be sold quickly. And sometimes we can go to court and shorten the period, but you got to start moving. Now, sometimes you need court permission to sell real estate. And that usually comes up when it's either no will, or the will doesn't give permission to sell, or we want permission to sell within the creditor period. We might have to get court permission. And if you need court permission, you can't sell it without that actual order, and nobody's going to insure it. So as I said, we need court permission if we have a bad will or a homemade will, because those are the ones that are most likely to not put in the provisions that avoid court approval. Now, property can be sold during the creditor period, but the proceeds will have to be held in escrow for the creditor purposes. And then at the end of the creditor period, you could distribute. And as I said, probate creates delays. The other issue is at homestead property, because you can't just distribute your homestead property the same way you distribute other property. If you have a spouse or minor children, you have to provide for them. So we can't just leave property necessarily to whomever we want. I'm not going to have a whole probate discussion here because you'll all kill me and we'll all fall asleep, but homestead property in the state of Florida is treated very differently. It's actually not technically even a probate asset, even if it's in my name alone. But Broward County and many counties actually require you to do the probate, even though it's not a probate asset. So we'll just leave it at that as to why that makes no sense. And that's how it changes things. So you want to get the appraisal. And this is why the realtors need to have some kind of a working knowledge of the probate proceedings. You're not attorneys, but you need to know what's going to happen if that property is still owned by the decedent, and you need to make sure that the property is owned by the people who are listing it. I can't emphasize that enough. And the title issue should be determined quickly. I'll talk about out-of-state property in a little bit. Ask questions of the probate attorney. So as I said to you, it's not uncommon for clients to come into us and tell us that they are selling property, and for there be closing dates and everything, and to find out from the closing agent that, oops, this person doesn't own the property. Just because they're named in the will as the personal representative doesn't mean they own it. Only the court can name the personal representative, and only the personal representative can sell it, and they have to be named by the court, and there has to be an order. Believe it or not, that happens more than you think. Now, I've asked some realtors, do you know A, B, and C? And they look at me like I have 10 heads. But since this happens with more frequency than you think, it's important that everybody who deals in real estate or selling it understands that you need to be the owner, and the personal representative is technically the owner. Okay. Okay, why isn't this turning? Oops. Where am I going? No. Okay, what's the difference between a will and a trust? Think of the will as a GPS. The will says where something is supposed to go. The trust is the car and the GPS. So the car and the GPS actually get you there. The car holds people. Trust holds assets. The GPS or the will doesn't hold anything. It's just directions. It doesn't get anybody anywhere. So the will is effective only on somebody's death, and the trust is effective when it's signed. So when we sign that trust and we let's say it's my trust. So I'm going to have the Alice Ryderfeld Trust. I'm going to be my own trustee when I set up that trust. I'm going to be able to buy, sell, spend, revoke, amend, do whatever I want with the trust. And it's effective when I sign it. But I can amend it. And then typically at my death is when you will look at the successor trustees, and then they will distribute the trust assets. And the creator of that trust is in full control during their life. The will only becomes effective on death. So a person can do, 15 wills, and you have to figure out which is the last will or whatever. The trust is just a really cool way of avoiding the pain in the neck probate property. So this is a little chart. I just think the important part is to know that that the trust avoids the probate. Anything that's titled in that trust is going to avoid probate. Anything that you have titled in your own name alone is going to go through probate. So if we have a will and we need to look at the will to see where something's going, that's a probate. The assets in a trust avoid probate. So when we do a trust, the goal is for all of our assets, or almost all of our assets, to be in the trust. I can revoke a will anytime I want, and most trusts I can amend or whatever. Trust is private and a will is public. So that's a little chart. The important thing in that chart is to know that the will covers all of the probate assets, those things in your own name. The trust covers the assets that we title in the trust. So how do we avoid probate? The most common way is to have a revocable living trust. So it avoids the delays. It's a very flexible document. It'll look a lot like a will. If you want professional management, you can do it with that. I can set it up so that money doesn't go out to children immediately, that it goes over a certain period of time, or that it's held for a certain period of time or a certain age. It provides in there that if I become disabled, my trustee can manage my affairs during my incapacity. Overlaps a little bit with my power of attorney. There's two things here. It avoids a guardianship for minor children, and it avoids the court being involved in handling the assets of minor children. So that whether you have minor children or your children do, they absolutely need to set up a trust. Otherwise, if something happens to them, the court's going to be involved and the kids are going to get it at 18. So we don't want the courts involved. We don't want the kids to get it at 18. And we want to make sure that the kids are protected and there's somebody named. As I said to you before, a trust will reduce the likelihood that a will is contested because, again, you have to sue that trust. It coordinates the distribution of assets in one vehicle. I like to think of it as a funnel. All of your assets go into this one place, and then you say how you want it distributed, 10%, 15%, 20%, and it's nice and coordinated, as opposed to bunches of assets all over the place and a will. That just never works right. It provides maximum privacy. It's really not that expensive to set up. It's certainly way, way, way less expensive than having any kind of a court proceeding. So the question that I will get asked often is, why don't I just put a beneficiary designation on all of my assets? And the answer to that is because you don't want a disaster. And I'll give you a couple of disaster explanations. But this is my favorite disaster story, if there's such a thing. I had a woman who I did a trust for, who I did her estate planning, and she had most of her money in an account payable on death to her 2 children. So far, no problem. Her daughter died before her. She didn't even know her daughter died. The daughter died about a month before her. And everything is payable on death to the 2 children. Now, with stock accounts, you can sometimes say what happens if one of them predeceases, but not usually bank accounts. So in this particular case, who inherited everything? Well, the son inherited everything because he was the only one left on the account that was alive. So you can't have the flexibility with accounts and bank accounts, brokerage accounts that you can have with your trust in making provisions. So when they were sitting down in my office, do you think that the brother, for a month, you think that the brother was giving his niece, as it turns out, 50% of the estate, the 50% that her mother would have gotten if she just lasted another month? No. So you can't trust people to do the right thing, nor should you even try to trust people to do the right thing, and not set it up that in ways in which you're going to have problems. The other thing people try to do with accounts is they try to just, I want something to go to the grandchildren. So they set up accounts, and they're never equal. They're never the same. They're always trying to balance out because they use some money for themselves. So it just really makes it hard to be very organized. Those are the ones that really create problems. So you don't want to avoid, I mean, I'm not saying you can't have something payable on death to somebody. Absolutely, that happens, but we try to discuss that with our clients and have them understand the ramifications of it. Okay, so what's the catch? The trust must be funded. We have to put the assets into the trust. Otherwise, it's not going to work. Funding means you have to title the assets in the name of the trust. And we used to give our clients instructions on how to do this. Now we just make sure that we do it with them so that it gets done right. Okay, so you can answer these questions to yourself. True or false? I only need to go through probate if my estate is large. That should be false. You go through probate if you have probate assets, ones that are in your name alone. Whoops. If I die without a will, the state takes everything. How many of you have heard this from people? It's ridiculous. If you die without a will and you have things in your own name, the state doesn't take everything. The state has statutes that tell the court where to send the assets, so to where the assets should go. So the statutes provide for it to go the way they believe most people would want it to. So if I die without a will, let's say I have $50,000 and they're going to say, well, she probably wanted it to go to her spouse or her children, and there's a percentage. They provide for that. There's no the state taking it all. The will avoids probate? No, the will is asking for a probate. If we're relying on that will, we're going to have a probate. A pour-over will avoids probate. A pour-over will is what we do as a companion to a revocable living trust. When we want to make sure that if somebody forgot to title something in their trust, that the court will pour it into the trust so it goes the way the person wanted it to go, and not by, as we said before, how the laws say it should go. So let me give you this as a quick example. Let's say I have 3 children and I don't get along with one of them, and I have a trust and I leave everything to 2 of my children in the trust, and that's where I want it to go. And I don't have a pour-over will for that $10,000 that I forgot about. That's going to go to my 3 children equally, because if I don't have a pour-over will to pour it into the trust, it's going to go the way the statutes say. So that's the companion. If I have a will, no one can contest my estate. No, just the opposite. It makes it easier to contest the estate. Probate fees are astronomical. No, they're not astronomical, but they are more than planning in advance. Planning in advance for this, for Medicaid, for anything, always, almost always saves money, time, and aggravation. An attorney is not needed. So we heard before that an attorney is needed for probate in the state of Florida. Probate takes years to complete. No, it can take 6 months to a year if it's not a particularly complicated one. A trust is the only way to avoid probate. And we saw before, we can have payable on death accounts or beneficiary designations. We just want to make sure we coordinate everything. I can do a will with a do-yourself kit. Oh, that should be kit. Yeah, you can, don't. Probate is required only in the state where you're a resident at death. This is important to understand. If you own real estate in another state, so let's say you have a condo in a co-op in New York and a condo down here, you need to have and they're in your name, you need to have a probate in both states, because we consider real estate to be attached to the land. Maybe a co-op is not a good example, but a condo in both states are real estate in both states, and you need a probate in each state unless they were in a trust. So you really want to do a trust if you have out-of-state real estate or even timeshares or things like that. A trust avoids probate. That's true, but only if it's funded. There are higher taxes with probate. No, that should be there are higher taxes with trusts or probate. There are not. Your taxes are your taxes regardless of how the assets get to people. They're tax neutral events. That should have been trust. Courts can change what the testator wrote in the will if you can prove that that's what the person wanted. No, the court's not going to change anything that's in the four corners of that will unless there's proof that there was some kind of fraud or the person was incapacitated when they did it. They're going to look at the four corners of that will. They're not going to care how much planning I intended to do for the last 2 months to leave everything to Bob, who's on the call. Bob's going to get nothing unless I actually do it. So they're not going to fix the wills for you, no matter what somebody promised they're going to do, unless the will is really, you can't understand it, or you have real proof of fraud or something like that. Oops. Oh, is that it for that one? Okay. The will is your most important estate planning document. No, you've seen that through this process that if we do it right, we're probably not going to even need the will. Now you might need a will to transfer a car or some other things, but the point is mostly everything should go outside of the will. That is not your most important estate planning document. Your most important estate planning document is your durable power of attorney. So your family or whoever can make decisions for you if you're incapacitated. Dead is dead, but incapacity can last forever. And if you don't have durable power of attorney, we have to go through a guardianship, which will be another program that we have. But it's not your most important. And when you keep reading that people don't have wills, yes, of course we should have a will, but there's so much more to doing this right. My entire estate goes through probate, even if I have only one probate asset. No, just the probate asset goes through it. So these are some misconceptions that people have. What's a proper estate plan? It represents your values and desires. It represents what you want to leave behind, not just money. It takes your family members and their situations into account. Can they handle money? Can't they? Do they have creditors? Are they getting divorced? It minimizes taxes, fees, time, stress, and costs. We want to do as much of that as possible. It will prepare for incapacity, not just death. In the old days, estate planning was just death and taxes. It's not like that anymore. People used to die, and I know that sounds like a joke, but they got sick and died. I mean, President Roosevelt was 63, President Johnson was 64. People died young. People now live long periods of time with incapacity. So I know this isn't part of a probate, but it's just my important lecture. You have to have somebody who can make decisions while you're incapacitated. So you want to make sure you have all of your legal documents prepared, your trust funded, your assets are retitled, you double check those beneficiary designations, and you have a checklist prepared. And if somebody wants, I can give the checklist, which includes, and this is the new thing, your passwords. You have no idea what a problem it is if people can't get into accounts and they don't have passwords, and how much easier it is if they do. Okay, so I'm going to open this up for questions, and I'm going to do that you're going to put in there that you have within the chat thing, and you're going to ask me any questions that you might have. And I'm looking towards to make sure I do this right. Okay. So where? Okay, just let us make this so you can ask a question. I tend to try not to use PowerPoint. So when I'm using a PowerPoint, it's set up a little bit differently. Okay, so anybody who wants to put a question in, please feel free to. Your chat is now available. Oh, come on, somebody's got a question. Okay. So first question is, somebody's not sure. I understand my personal representative has to be in the state where I live. Under Florida law, your personal representative has to be a close family member, which usually ends that issue, or live in the state of Florida. So as I gave you that example, my dearest friend and one of my dearest friends in the world who lives in Staten Island, who I consider a relative and call my sister-in-law, isn't my sister-in-law. She's actually not related to me, and she can't be my personal representative. But if it's a family member, child, husband, even cousins and whatever, they can be your personal representative. Somebody said, this was wonderful. I'd like to come and get an appointment. Well, we'd be more than happy to meet with you. Make sure that everything is good. All my assets are payable on death except my house. I am all set. No. First of all, your house is not payable on death. So now we're going to have a house that goes through probate. And depending on who it's payable on death to, what if that person, if there's more than one person, what if one of those people passes away? We talked about that problem. What if you change your mind and you don't change it, or somebody is not available? Payable on death, if you have one child, isn't so bad. If there's more than one and something happens to one, that could be a real problem. So payable on death, plus we're going to do something with the house anyway. Now, if you tell me you have a very small estate, it's $10,000 in just my house, we're probably not going to go through a trust. Trust isn't for everybody. It used to be, when I started practicing law, that everybody was mad at lawyers because everyone said, well, they want the probates, they'll make more money. Nobody's telling us to do revocable living trusts. And then 10 years later, it was all they're doing is selling revocable living trusts. Probate's not so bad. So as you saw, well, the trusts are probably better. Nothing is a catastrophe, but usually it's better to avoid it. But if you don't have the house in the trust, then we're going to have a probate if you don't take care of that. So we're going to take a look at those payable on death designations and make sure that they're consistent. And if they work for you, no, I don't force anybody to do anything, but we do have to do something with that house. So let me understand, only the person designated as the executor can sell the property. Only the person who the court names as the personal representative can sell the property. So let's say I have a will and I name my son. Let's say I name my dear friend in Staten Island as my personal representative. I may have designated her as my personal representative, but she's not qualified in the state of Florida. So the court's going to appoint my alternate. Hopefully I have one. Let's say that's my brother. So the only person who can sell the property is the actual person the court names as personal representative, not the person I necessarily named in my will. So it's a really good question. Usually it's the same person, but not always. So if we know it's a close family member, no problem. But if I say my sister-in-law, Melinda, on my document, she's not my sister-in-law. I call her that for a variety of reasons, but she's not a close family member. She's not a family member. And so it's who the court names can sell the property, unless of course it's in a trust. What's the best way to title a car? That car is the exception to all of the rules. It's the only thing that you can own in your own name and won't actually go through a probate proceeding. You can actually title a car to the owners without a probate. The best way to title a car is not to make other people responsible for accidents. So I generally tell people to have it in your own name. So not so that you and your husband are both responsible for debts. But again, that's something I might want to ask a few questions for, but that's generally. If a will states that all of my tangible and intangible property goes into my trust, are those items considered assets or trust property? Well, technically, if you haven't assigned those items of personal property, and it's personal, we'll call personal property, not intangible, that's real estate or something. It's going to be your personal property. You should assign it to the trust. But the truth of the matter is, if you've got a little jewelry, it's going to be split up in accordance with a writing that we're going to have you do. So those are, if there's no writing and it's a lot of valuable things there, it's going to be part of your probate estate, and we'll have to probate those 10 rings and 15 paintings and all of that. So it depends. Technically, you should assign your tangible personal property into a trust to make it part of it. Most of the time we don't, but not your intangible. You can't assign a bank account or your real estate into the trust. You have to retitle. Great presentation, thank you. You said estate planning is not expensive. What are some ballpark figures? I have no idea. I didn't say it wasn't expensive. I said compared to doing a probate, it wasn't expensive. And expensive is in the eyes of the beholder. So to some people, $100 is expensive. To some people, 10,000 isn't. It depends on what you need. If you come in here and you don't have anything and you just need documents, it's going to be relatively inexpensive. But if you come in here with, $2 million and 54 accounts, it's going to be a little bit different. So I really can't give you a ballpark. Everybody asks that question, and I don't like try to be difficult, but I just can't. How can you reach or find the personal representative if someone is listed and the property passes away and the listing agent doesn't return your call? How can you reach or find the personal representative? Well, you can look in the court records to see if there's been a personal representative name, but the listing agent doesn't really have anything to do with who the personal representative is. You'd want to look in the public records and see who's been named a personal representative, and then deal with the listing agent. A listing agent's not going to really talk to anybody but the personal representative. So, please, remember that they have a fiduciary duty to keep it, personal. They're not going to answer questions for anybody unless they're given permission to. Oh, from Bob Sutton, Alice, my attorney, who is an attorney's attorney, has stated that you should talk to her in person. Can I arrange a meeting? Yes, you can always come in whenever you want to, Bob. And I didn't tell him to say that. It's interesting to note that a will is not the end all be all of estate planning. That's right. It's not. It is not the end all be all of estate planning. I can't begin to tell you the wrong information that's out there. I've been doing this for 30 years. And if one more person tells me I have a will, therefore I'm not going to have probate, I'm going to punch right through this PowerPoint, right through the computer. A will does not avoid probate. You have to have some trust or other way of doing it. All of my assets are payable in death or list beneficiaries. Do I need a will to adjust my stuff? Everybody should have a will, because you don't know that you didn't forget a bond there, here and there. You should have a will, and we usually put a list of personal property on the back. We talk about personal property other times because sometimes people have very expensive personal property and we don't want the family to fight. I had a situation once quickly where a grandmother, she wore her diamond ring all the time. She never took it off. She could be folding the laundry, doing the dishes, whatever. It was on her hand all the time. And when she died and they went to the jeweler with it, turned out it wasn't real. And siblings accused other siblings of moving the diamond and taking it out. So, be upfront and honest with your family about stuff, because that really stuff can create problems. A mobile home is considered like a car. We would title it into a trust, though, not like we would a car. It's considered real property. Now, the real estate under it, if you own it, that's real estate. But just the mobile home is like a car, has title, and we could title that into a trust. What should I bring with me to our meeting? You know what happened. You know the answer to that question. You're going to call Tracy, and she's going to tell me, or call me tomorrow, and I'll talk to you about what to bring. Do I need a will if all my assets are payable in death or list of beneficiaries? So that's the same question. Yes, even though I said the will isn't your most important document, I didn't say you shouldn't have one. That's how we decide who the car gets. That's how we decide who certain personal property goes to. You still should have one just in case there's an asset out there you haven't titled. It's just not as Bob said, not the be all end all. It's just part of the whole package of documents. Okay. So understand that we don't what we don't want to do when we do estate planning is solve one problem and create another. So if we take shortcuts, and sometimes payable and death are shortcuts, sometimes they're not, but if we take shortcuts to avoid a probate and we create another problem, that's not our goal. So again, sometimes that's appropriate. We have a small estate, whatever. We certainly don't do a trust for all our clients. But sometimes we create more problems with something than we intended to, because we're trying to circumvent something and not spend money. And this is an important thing for everyone to do. And whether you do it with me or you do it with somebody else, do it with somebody who does this for a living, does estate planning or elder law all the time, not your divorce attorney or whatever, or even the real estate attorney. Do this with somebody who knows what they're doing so you don't miss anything. One of my favorite expressions is people don't know what they don't know. So when mom said, I've got it all wrapped up for you, to my friend, she didn't have it all wrapped up. She thought she did. And maybe the attorney said she did, but she didn't. So we don't know what we don't know. And with that, I'm going to let you all go. Have a wonderful, wonderful evening, and stay tuned for, I'm going to try to do one on guardianship next time, but we'll see about that. But I'm going to be doing them at least monthly. If you want to schedule a meeting with me, you just need to call the office. Our number is 954-726-6602. Or you can email me at alice@florida-elderlaw.com. Somebody had, oops, they sent something to everybody. That's okay. I've been doing it before too. So I'm looking forward to meeting with you. I know there's some realtors on the call. I'm always happy to answer the questions of, allied professionals if you have them. So by all means, feel free to give me a call if you have any questions with, general ones or a specific sale or something like that. Again, everybody, good night and have a great evening, and we'll see you again soon. Bye now.